This is Palworld. A family-friendly game enjoyed by millions. And now, it's being sued by Nintendo.
Hi everyone, I'm Shigeru Miyamoto.
While a lot of people foreshadowed the inevitable legal action by Nintendo against Palworld, mostly for ripping off their copyright in design thanks to similarities and very apparent inspirations between characters in Palworld and those in Pokemon, Palworld recently released a public post on their website highlighting the exact grounds on which it's being sued by Nintendo. And it isn't exactly what people thought it would be. You'll want to stick around for this one. Before we dive in, a quick disclaimer. This video is for informational purposes only and does not constitute legal advice. I'm sharing my insights based on publicly available information and my own professional experience. Hey, it's Harriet. I'm a corporate lawyer and I've embarked on a wild journey. Wait, what? This isn't that video? Oh, my bad. Force of habit. Before we get started, let me just put out my credentials. I specialize in mergers and acquisitions, private equity, venture capital, and other corporate transactions, and have been a professional for more than 4 years and studying law over 9 years. So I know a bit about law. But enough about me. Today we are diving into the wild legal battle between Nintendo and Palworld. Released on January 19, 2024, Palworld is a Pokemon-inspired game that took the world by storm. Developed by Pocket Pair on a budget of around $10 million, they decided to mix the pocket-friendly charm of Pokemon with the gritty survival elements of base-building games. It sounds like a strange combination, but it worked. The game broke multiple records, including the highest number of concurrent players, twice. By February 2024, Palworld reportedly raked in $442 million and sold over 15 million copies. Not too shabby for a game where you can create your own monster factory and find creative ways to deal with the wild pals. So, what sets Palworld apart from other games inspired by Pokemon? I think it's the game's willingness to dive into mature themes and aspects, offering a fresh twist that resonates with older audiences. While Pokemon tends to keep things kid-friendly, Palworld isn't afraid to push the envelope. I mean, just look at this video from Pocket Pair. Yep, they went there. When was the last time you saw Pikachu getting grinded to be put into a salt shaker? But with great success comes great scrutiny. Soon after its release, and I think even before, people drew many parallels between the resemblance of some of the pals and the Pokemon. Take Anubis and Lucario for example. The resemblance is hard to ignore, and that's just one of many. So, the internet did what it does best. Investigate all dark, hidden secrets of Palworld's creation. From claims of outright copyright infringement to alleged former game designers accusing Pocket Pair of stealing Nintendo's IP, the rumor mill was in full swing. There was even a heated debate about the alleged use of AI tools in designing the pals. People dug up old tweets from Pocket Pair's developers discussing AI and its impact on art creation. Given the complexities and controversies surrounding AI-generated art, especially when it comes to potential copyright issues, the situation looked grim for Palworld. However, over time, many of these claims were debunked or clarified, but the initial suspicion added fuel to the fire. People on the internet have found themselves on both sides of this contention, both defending Palworld and also trying to rip it a new one. And people did point out the impending lawsuit Pocket Pair would be subject to for ripping off Pokemon characters. Amidst all of this, Nintendo finally broke their silence. They announced they were aware of Palworld and intended to investigate and take appropriate measures to address any acts that infringe on the intellectual property rights of Pokemon. Translation: we are watching you and we might just sue you. Now, let's get one thing straight. Inspiration isn't illegal. Creativity often builds upon what's come before. Think about how many games, movies, and books draw inspiration from existing works. It's when that inspiration crosses into direct copying that you run into legal trouble. In the case of Palworld, while some pals resemble Pokemon, they're not identical clones. Unless a character is indistinguishable from its inspiration, claiming copyright infringement becomes challenging. So, at this point, Pocket Pair seemed to be on solid ground, legally speaking. Let's take a quick detour to 1980s, a time for big hair and even bigger lawsuits. Look at the case of Atari versus Philips, for example. Atari sued Philips over Casey Munchkin, which, aside from having nightmare-inducing cover art, bore a striking resemblance to Pac-Man. In assembling the facts of the case, the court pointed out that plaintiffs, in this case Atari's, audiovisual work is primarily an unprotectable game, but the particular form in which it is expressed, shapes, sizes, colors, sequences, arrangements, and sounds provides something new and additional over the idea. They concluded that, although not virtually identical to Pac-Man, Casey Munchkin captures the total concept and feel and is substantially similar to Pac-Man. This case is a far cry from those in which the defendant appropriated only the game idea but adopted its own unique form of expression, leading to a ruling in Atari's favor. But here's the thing, that was then, and this is now. Graphics and game design have evolved tremendously, making it harder to claim that one game copies the total concept and feel of another. PAL in Palworld do not copy the complete feel and concept of a Pokemon, not just due to their visual and sound design alone, but also because of the setting surrounding them. A bunch of Pokemon running around with high caliber ammunition isn't the feel Nintendo is going for. So, Nintendo can't claim infringement, and Palworld is in the clear, right? Well, Nintendo never disappoints. Just when everyone thought Nintendo might let this one slide, they pulled a fast one. On September 19, 2024, Nintendo announced that they are formally filing a lawsuit in Tokyo District Court against Pocket Pair. But here's the twist. They weren't suing over copyright infringement due to character similarities. No, they are pursuing a patent infringement case. Wait, what? Patent infringement? Now that's a curveball. What's this all about? Time for a quick legal lesson. Intellectual property can be protected in several ways: copyrights, trademarks, and patents. Copyrights protect creative works like art, music, and writings. Trademarks protect brand names, slogans, and logos. Patents protect new and useful inventions and processes. Remember the Pac-Man case we talked about? The court had observed this: plaintiff's audiovisual work is primarily an unprotectable game. That's because a game's mechanics, concepts, and gameplay cannot generally be protected as copyright. They are part of patents. So, what are the exact patents Nintendo is alleging Palworld infringed upon? Pocket Pair recently released an update on the lawsuit which highlighted the claims, meaning demands, made by Nintendo along with the details of the patents which Pocket Pair is accused of infringing. But does Nintendo have a strong case to allege such infringement? And what is this exactly about? Let's dive a bit deeper, and oh boy, what I found was very intriguing. According to Pocket Pair's report, Palworld is alleged to infringe on the following patents held by Nintendo. Patent number 7545191, filed on July 30, 2024 and registered on August 27, 2024. Patent number 7493117, filed on February 26, 2024 and registered on May 22, 2024. Patent number 7528390, filed on March 5, 2024 and registered on July 26, 2024. Essentially, Nintendo is claiming that Palworld copied specific gameplay mechanics from Pokemon Legends Arceus. But which ones exactly? Let's unpack this. I will broadly summarize the patents because, let's be honest, I don't want to sit here narrating for an hour the whole text of claims and descriptions of the patent, and you aren't interested in the technical verbiage of this document. The primary claim of patent number 7545191 is to protect a game system where, when a first category group including a plurality of types of capture items for capturing a field character arranged on a field in a virtual space is selected, the player character is made to take a stance to release the capture item. When a second category group, including a plurality of types of combat characters, is selected, the player character is made to take a stance to release the combat character. If this sounds familiar, it's because this is how capturing and combating in Pokemon Legends Arceus works, where you take a ball, throw a ball, and depending which ball you threw, you either capture the Pokemon or release your own Pokemon in the world. This is also what Palworld does. Apparently, Nintendo does not see a difference between Pokemon Legends Arceus and Palworld. I'm joking. But when you think about it, a host of other games do the same thing, right? You throw a ball, you capture the monster. They've existed for a while, so why hasn't Nintendo sued them all to the ground? They have the patent after all. In fact, people have pointed out that Craftopia, Pocket Pair's earlier game and released before Arceus, had a similar mechanic for capturing animals. So clearly Nintendo must have lost it, or had not done its due diligence, right? Well, not really. Nintendo is not trying to patent the throw ball capture the Pokemon game mechanic. In fact, Nintendo's own patent in its description states that there are game programs in which a player character throws a ball at a character in a virtual space, capturing a character and setting it in the player's character's possession. Nintendo is aware this idea is not unique or something they can try protecting. After all, Nintendo wasn't the first company to have thought of this mechanic in the first place. So, what is the patent for? While the patent itself is broadly worded, what I think they are looking to target is the ability to capture the pals without engaging in the battle. And from what I have been able to research so far, you cannot do that in Craftopia. Let me know if I'm wrong though. Patent number 7493117 is similar to the first, focusing on variations of capture mechanics. There may be technical differences and differences in verbiage, but conceptually, they're trying to protect the same thing. Lastly, patent number 7528390 claims a game system where a player character can ride different types of rideable characters owned by the player, each with unique movement capabilities. While this concept is not inherently new, their patent aims to provide a seamless switch between multiple boarding objects in a game. And interestingly, that is questionable in Palworld. The description of the patent further goes on to state how mounts work, stating, a water-based boarding character is a boarding character that can move on water or underwater, but cannot or has difficulty moving in areas other than on water or underwater. To me, it seems like their target is pals like Surfette, which can operate both in and out of water, but have difficulty due to its reduced speed operating on ground. But you would say, how does any of this even matter? All these patents have been filed for and registered after Palworld was already released, and anybody trying to apply for a patent needs to do its due diligence. So did Nintendo just forget about Palworld, a record-breaking, highly publicized game, while trying to file those patents? Here's where a crafty side of Nintendo starts to appear. All of the patents Nintendo has alleged Palworld to be in the breach of are filed after Palworld was already released. But they're not the original patents, they're divisional patents. A divisional patent allows a company to split an existing patent application into multiple ones, often to refine and expand their claims. This means Nintendo can adjust their patents to cover new developments they see in the market. By doing this, Nintendo can claim that their patents were in effect from the original filing date, which goes all the way back to 2021, even if specific claims were added later. It's a common strategy to extend the scope of intellectual property protection. It makes it easier for companies to keep evolving their patents and cover claims their competitors may make. In fact, if you compare the language in the original patent and the patents in question, the new patents are substantially differently worded than their original counterparts. So what does this mean for Pocket Pair? Let's look at the claims. Nintendo is seeking an injunction to prevent Palworld from most likely being sold and updated. They're also asking for 10 million yen in damages, which roughly is about $65,000. That might seem like pocket change compared to Palworld's earnings, but it's not out of the goodness of Nintendo's heart, it's because of the law. Japanese law does not have the concept of punitive damages, only compensatory damages. Compensatory damages are the damages that a court awards as a compensation for the loss that has been suffered. Punitive damages are the damages that a court awards to punish the other side for being a bad actor. So, in the absence of any punitive damages, the injunction is the real issue. It could significantly impact Pocket Pair's operations and future plans. Some might say, just settle and move on. But it's not that simple. Settlements can come with conditions like altering game mechanics or paying ongoing royalties. Plus, agreeing to a settlement could set a precedent, making Pocket Pair vulnerable to future claims. But patents are national. Patents don't get international protection automatically, and you have to register them individually in each country or region where you want them. So, the injunction against Palworld will only operate in Japan at best, but that is also one of the biggest markets for them. So, what's Nintendo's endgame here? Is it about protecting their intellectual property, or is there more at play? Some might argue that Nintendo is trying to stifle competition, especially from a game that combines elements similar to theirs, but with a fresh twist that resonates with older audiences. Did you know that aside from having patents in Japan, Nintendo also has the same patents in question filed in US? Well, this is where speculation comes in. And I need to emphasize that the upcoming segment is opinion heavy and contains a lot of speculation. Here's what I think happened and will happen. Pokemon Legends Arceus was revealed in February 2021. Palworld was announced in June 2021. Nintendo might have underestimated Palworld initially, but grew concerned as it gained traction. They developed a strategy involving divisional patents to strengthen their legal position, and if successful, Nintendo might pursue similar actions internationally, potentially in the US, where punitive damages could be significant. It's a strategic move that big corporations sometimes make to maintain market dominance. And if I was developing a legal strategy, that's what I would shoot for. You want to use the Japanese litigation as a distraction, and if you win, it's a precedent. Also, the threat of a US litigation would always loom over Pocket Pair, and the time lost of Pocket Pair's developers cannot be repaid by any amount of money. So, what happens now? We wait and see how this unfolds, and where Nintendo and Pocket Pair end up in this legal battle. Here's my 2 cents. There's a fine line between defense and suppression. Innovation often comes from building upon existing ideas. If we start patenting broad gameplay mechanics, we risk stifling creativity in the industry. It could discourage indie developers from experimenting, fearing legal repercussions. Nintendo has a history of being protective, sometimes to a point of alienating their fans and creators. In this case, I believe they could have taken a different approach, perhaps collaborating with Pocket Pair or finding a mutually beneficial solution. Nintendo, this is my open letter to you. You have been a cornerstone of gaming world, inspiring countless players and developers, including myself. Embracing competition and innovation can lead to incredible advancements. Instead of legal battles, consider the possibilities of collaboration or dialogue. Sometimes, winning isn't about defeating others, but about uplifting the entire community. Let's keep the spirit of creativity and fun alive. Well, that's about it for this video. Thanks for joining me on this legal journey through the wild world of gaming. What do you think about Nintendo versus Palworld situation? Should the patents cover game mechanics like these? Do you believe Nintendo's actions are justified? Are they overstepping? Let's get a conversation going in the comments below. Your insights could spark an important discussion in the gaming community. If you enjoyed this deep dive and want more content blending law and gaming, hit that like button and consider subscribing. It really helps me out and costs you absolutely nothing. No damages here. Also, don't forget to check out my 12 in 12 challenge series, where I'm attempting to master 12 competitive games in 12 months while balancing my life as a corporate lawyer. It's as chaotic and entertaining as it sounds. Until next time,